means the place of the thoughts. Traditionally, most countries believe that the place where the thought occurs should apply. And this was the case in Tolofson versus Jensen, where the Supreme Court of Canada said that let Loti Delisi emphasizes that the law of the place where the thought occurs should apply, even if it leads to outcomes that may seem unjust to the parties. We can say that the foundational case can go far back as the case of Philip versus L. It's one of the cases that most of the courts relied on in reaching their decision when relying on the law of the place of the thoughts. However, critics have argued that this rigid application can result to unfairness if the court is relying on applying the law of the place. So some of the school of thought is that we should rely on the place of the injury or the place of the acts, or parties should be allowed to decide, or we should use forum shopping when
What is the difference between the place of are you saying that the place of the act cannot also be lex loci delicti? Lex loci delicti means the place of the thought.
Yes, sir.
And the place of the thought has several meanings.
Yes, sir.
Okay? The place
Yes,
of the thought has several meanings. It can be the place of injury. It can be the place where the act or the omission was done.
Yes, sir.
It can also be, some American cases call it, the place where the last act to constitute the thought was done.
Yes, sir.
So, lex loci actus is also the same as lex loci delicti. The meaning is that you are describing the place of thought as the place where the assailant did the act which resulted in the injury. Which
Very
could
correct,
also,
sir.
So, so the two, lex loci damni, lex loci actus, are the two different meanings of lex loci delicti. Okay?
Okay, sir.
Go to proper law of the thought as a
Okay,
test,
sir.
as a
Thank you, sir.
connecting factor.
Thank you, sir. Proper law of the thought approach seeks to identify the legal systems which most significantly is related to the Torturers Act. In the case of Boyce versus Chaplin, the House of Lords, which I would say is the most appropriate, that will hardly have criticism. The House of Lords endorsed this approach, stating that the law of the country that most significantly is related to the thought should be applied. This decision marked a departure from the rigid approach of the law of the thought, the place of the act, or the place of the injury. That is the significance of this proper law of the thought, sir.
Who is the proponent of proper law of the thought suggestion?
I know that it is restated in the restatement second of conflict
adopted
of
in the
laws.
second
Yes, sir.
restatement of
The
conflict of laws in
US.
America.
Yes,
But
sir.
the original author of that principle is Professor Morris.
Okay, sir.
Professor Morris is the original author of Proper Law of the Tort. And because we may not have time, his reasoning is that if a tort has multiple contacts with different legal districts, there is nothing wrong in applying a principle, a connecting factor that has been applied to contracts, which is the law with the most significant contacts. You look at the different countries and their involvement in the issues, and you will zero in on the legal district with that, in your own view, can constitute the center of gravity that has more of the useful contact with the matter. That's what we call proper law of the torts.
Yes, sir.
So we are go to 2.5, party
Okay.
autonomy.
This party autonomy refers to parties being able to decide which law should apply or which court should have jurisdiction. It happens in our everyday practice where parties will incorporate it into their contract. So the court recognizes that paragraph of their contract and enforce it to make it easier and reduce the burden of determining which court should have
Should party
jurisdiction.
autonomy apply to tort? Should it apply to tort? It makes a lot of sense in contract because contract is an agreement. And the assumption is that parties, since in agreement it is parties that are making laws for themselves, the parties could as well agree on under what country's law would their dispute be resolved. But you can never predict where and when a tort will occur. And in a product liability dispute, you are talking about the possibility of a product being manufactured somewhere, being bought somewhere, being used somewhere, and injury being suffered from the use in yet another place. So how would parties, how will an agreement, a prior agreement, between who and who will the prior agreement work?
Sir,
Because there will be no contract. For example, you cannot be pointing to a contract between the party who is injured and the party who manufactures. Do you
yeah,
understand?
I do, sir. Article 14 of the Restatement Second of Conflict of Laws in the US.
Mhm.
It allows party to choose the
That's
applicable
what I'm
law.
saying. Parties can choose applicable law, but the usefulness of their choice will be very limited
Yes,
because
sir.
tort is different from contract. Do you
It is
understand?
contained in our paper, sir. We said it is less developed, but it is sometimes allowed if the court allows it.
It depends on the injury you are complaining about. If it's an injury if it is an injury arising from the product that is contemplated and there's a privity, between the parties, yes, you can apply contractual connecting factor. But in most of the product liability cases, the injury will be suffered at a place least expected. If a product is an international product and is manufactured in country A, it might pass through country B. Maybe it was acquired in country B. It might be in country D that it is used. So are you suggesting that when the product was being passed on to the user in country D, the contract between the original parties in country A was also passed on to him? Do you understand what I'm saying?
Yes, sir. I
So
understand you,
I'm
sir.
saying it's very, very really useful type of concept when you are talking about tort liability, because there won't be any privity. Most likely, most often, there won't be any privity between the last man to go to court and
The
and
manufacturer.
the other parties on the chain of relationship. So that's why it's not a particularly useful formula.
Popular formula. Yes, sir.
Yes.
Sir, but it is part of it, but it is not popular. So we would know, are we to state it or we should remove it? Because we stated by virtue of section 14, sir. We
So
also
we are not
stated.
going to say what you should say and what you should not say. We are just trying to uh, explain to ourselves. Go to your 2.7,
Thank you, sir.
the different point of connection. Yes. 2.7.
Yes, sir. I'm here, sir. Place of manufacture. That is where the particular product is manufactured or assembled or designed. Under traditional common law and civil law systems, the place of manufacture may serve as jurisdictional anchor. That is where the duty of care can be imposed. It is a secondary connecting factor under Rome 2 regulation,
Go to
Article
place of
5.
injury. We it's English now. We know place of manufacture.
Okay, thank you, sir.
Go to
Place
place
of
of injury. Move. We
Thank you,
have a
sir.
long way
Thank you,
to
sir.
go.
Place of injury is
Yes.
often treated as the primary connecting factor in tort-based product liability. It represents the locus damni. That means the place where the harmful consequences materialized. It formed the basis of the leg loci damni principle under Rome 2, Article 4, subsection 1.
You know
The
we are not treating European. Anyway, it's a comparative class.
Sir, we
We
do
are
not have.
go to contact number 3.
Okay, sir, I
What is
want to.
contact number 3?
Place of residence of the plaintiff. Sir, we
That
do
one is
not
very
have.
easy.
We do not have more of the Nigerian cases. We try to really sort for, but we have more of the Europe. Thank you,
Go
sir.
on.
Thank you, sir. The
So
place.
the third possible contact is the place of residence of the plaintiff.
Yes, sir.
Okay.
Yes, sir.
What is the fourth relevant contact?
Place of business of the defendant, sir.
Okay. Okay. So we have 4 different primary contacts. 1, place of manufacture. 2, place of injury. 3, place of residence of the plaintiff. 4, place of business of the defendant. Okay?
Yes, sir.
So how do we determine governing law between these 4 places? The usual issue is that the place of residence of the plaintiff might impose a higher standard of care than that of the place of manufacture. Okay? If you choose the governing law to be the place of manufacture, the plaintiff will feel cheated. Okay? The reverse may also be the case. The place of manufacture might have imposed a higher standard of care and might have awarded higher recovery than the place of residence of the plaintiff. Naturally, the plaintiff will want the law of the place of manufacture to apply. But if the defendant is the manufacturer, he would want his liability to be confined to the laws of the place of residence of the plaintiff. Okay? That is on the assumption that it is the consumer who is suing the manufacturer directly. The consumer may not sue the manufacturer. He may sue other people in the chain of how the products got to him. Okay? So, with this as our background, what is the choice of law rule that we should apply? That's what you are challenged to do. What is the choice of law rule we should apply? Okay? That's what you are challenged to do here. And in doing it, you are required to look at any existing arrangements and the traditional rules, the traditional choice of law rules in thought, and to tell us whether any one of them will be satisfactory. Okay? So, can we go ahead to where you discuss that? Is there anywhere where you discuss the applicability of the existing or traditional connecting factors? Hello? Go to part 4.
Yes, sir.
Go to part 4. Let's see what you discussed there. I hope the introduction is clear to the class. Product liability, they present more serious cases to us because of the multiplicity of contacts. A product could be manufactured in one place, sold in another, used yet in another, where it causes injury. So, different type of relationship would have been created along the line. And the law of different countries will be involved. What is the justice of the matter in determining the law to govern the dispute? Given that legal districts will not have the same rule, you could have You could have a territory of manufacture that imposes a very high duty of care and would be ready to award very high amount of damages. But the injury could have occurred in a place where the law cares less about injured than the law of the place of manufacture.
It's Ronaldo jumps like this, just like this.
Can somebody mute
Mr.
so that
Ronaldo jump
we
like
allow the children to be? So go to chapter 4 and let us see which of the traditional choice of law rules will do justice in this matter.
Yes, sir.
Are you the one who who was destined to present chapter 4.
Yes, sir.
Okay, go to chapter 4 now.
Yes, sir. In our chapter 4, we stated that the general rule aims to determine the jurisdiction most closely connected to the disputes. Common law approach includes the place where the tort occurred or the place where the damage occurred. Traditionally in Nigeria, we practice the double actionability rule, which was adopted from the common law rule. This was well demonstrated in the case of Benson versus Ashiru. Under the Rome II regulation, a unified framework for determining the applicable law in non-contractual obligations within the European Union. We talked about Article 4, subsection 1, where the law of the country where the damage occurred governs the tortious claim, irrespective of where the events arose. This principle is known as the law of the place where the damage occurred. So we are trying to say that under the Rome II
We
regulation,
understand you. We understand
thank you.
you. Go to Article 5.1. Is arrangement
Article
of a hierarchy of connecting factors.
Article what, sir?
It's just your next paragraph.
Oh, okay, sir. The Hague Convention, sir.
No. Is this a convention?
Okay, sorry. Oh, Article 5.1.
Wrongful regulation, yes.
Oh, okay, sir. Okay. It establishes hierarchy of connecting factors. 1, arbitral residence of the claimants. The law, that means the law of the country where the claimant had the arbitral residence when the damage occurred, provided that the product was marketed in that country. That is a clause, that the product was marketed in that country. Then the court may consider the arbitral residence of that claimant. Then 2, place of acquisition. If the product was not marketed in the claimant's country of arbitral residence, the law of the country where the product was acquired applies. Then 3, place of damage. In the absence of 1 and 2 above, the law of the country where the damage occurs applies. Article 5.2 introduces foreseeability clause, stating that the producer could not reasonably foresee the marketing of the product in a particular country. The law of the country where the producer has their arbitral residence will apply. These rules aim to provide predictability and fairness across border product liability cases, balancing the interests of the consumer and the producer.
Yes.
Then our 4.3 will talk about the Hague Convention, 1973.
Okay.
It provides a framework similar to the Rome II regulation, but distinct in application and scope. Article 4 of the convention establishes the law of the country where the damage occurs would govern the product liability claim. However, it allows for exceptions based on the circumstances, such as arbitral residence of the claimants or place where the product was marketed. This convention applies exclusively to the relationship between manufacturer and distributor and the person who suffered the damage. It does not address issues of jurisdiction or recognition and enforcement of foreign judgments.
And we are not interested in the two. Anyway, we are talking
Yes, sir.
about law. So
Yes, sir.
the convention is very relevant to us. Okay?
Yes, sir.
So where do we have the combination and permutation? You didn't discuss the combination and permutation of the Hague Convention. Hmm? You didn't.
I take
You
the
didn't,
hint, sir.
you didn't discuss permutation and combination. You didn't look at Article, I think 6 and 6. Article 6, Article 7.
Okay,
Article
sir.
6 of the Hague Convention, they talk about different contacts, about 4 of them. It talk about 2 major contacts and says that for any one of them to be the basis of determining liability, it must also be the same as one of another 4 subcontacts. For example, the Hague Convention says the primary contacts are the place of manufacture or the place of injury. To determine which of the two would apply, we will apply the one that also coincides either as the place of habitual residence or the place where
The damage occurred.
there are 2 main contacts. The 2 main contacts are place of manufacture, place of damage, or place of injury.
Yes,
So
sir.
the convention says, in order to determine which of the 2 will apply, we will look at which of them meets the other subcontacts. And the other subcontacts include place of residence of the party injured, place of carrying on business of the parties injured, uh, place of sale of the goods, a number of other contacts were listed. That's why we describe the convention as a convention of combination and permutation. Okay? You have not presented the convention properly. You need to go and look at the convention. Then the convention also talks about foreseeability. Yes, foreseeability. It offers the manufacturer a defense to say that he did not foresee that in the course of business that his product would be acquired in the place where it was used. So if he says he could not have foreseen that, then that would be a defense for him, or a basis of saying that the place of manufacture standard was not going to apply. Okay?
Yes, sir.
So you go
Sir.
and look at Articles 5, 6, and 7 of the Hague Convention. Give us the 2 major contacts. Give us the subcontacts, which any of the 2 major contacts must combine in order for it to apply.
Yes,
Okay?
sir. Yes, sir.
So at the end of the day, in modern time, what we want to do is to look at the previous efforts, the previous efforts that have been made by conventions to resolve the controversy of the choice of law in product liability cases. And you have given us 2 conventions now, even though you have not discussed them in any comparative details. That is what we should be doing in a class of comparative conflict of laws. After attempting to look at the traditional approaches to say that even without the convention, do we have any choice of law rule that is tailor-made for product liability? Okay. If you read the article, very old article that we are usually referred to, where one of the conflict professors comprehensively analyzed the Hague Convention. I'm sure it's part of the materials that I've referred your class to in previous classes. If you have it in your materials, go through it. And our usual worries is that none of the traditional approaches on choice of tort laws would ordinarily be satisfactory for product liability. If the traditional approaches like lex loci delicti, commissi, lex ori, double liability, proper law of the tort, etc., are not good enough, what of the agreement arising from conventions? That is where the European Convention you look at, which try to resolve the matter Europe-wide, and the Hague Convention, which try to resolve the matter as between all parties who are parties to the Hague Convention. Nigeria, you know, is not a party to the Hague Convention on product liability. Nigeria is not a party to any of the Hague Conventions up to today.
Yes, sir.
So, yes. So that is the matter. That is the issue. Okay?
Yes, sir.
So let me see whether there is anywhere you discuss. Forget about recognition and enforcement. It's not part of your topic. What else did you say? See, because you people don't have an idea of what you are directed to do, you scare us with the volumes of your writings. Okay? But I hope now you have understood what the task is all about.
Very well, sir.
Yes.
Well understood, sir.
We have traditional choice of law rules in tort. Lex loci delicti commissi, double liability, American second restatement, proper law of the tort as suggested by Morris, basic lex ori, and what have you. But all of those, none of those would be tailor fit for product liability problem because of the array of contacts. Okay, array of contacts that a product liability tort will present. So if the traditional choice of law rules of different countries, there is none that you can use as a model, is there any effort, any agreement, convention, whose model you can use? That is what has led us to examining European Convention and the Hague Convention. So understand the content of those conventions very well and form your own opinion whether they solve the problems that are highlighted. If you read that particular article, I can't remember the name of the author. but it's an article written around 1973, immediately after that convention was done by a professor of conflict who examined thoroughly the choice of law rule of the convention, agreed that it's an improvement on the traditional rules. As at that time, I don't think the Europeans have come with any solution. So it was the only first effort. And happily, being the Hague Convention is not limited to European countries. Okay, even though our own country has not joined the treaty. So at that time, he was looking at how much of the confusion that any of the traditional rules will create has been solved by the effort made in that convention. He had his own criticism of the convention, but he concluded that the convention is at least better than any of the traditional rules. So today, we have the benefit of a European convention, which geographically is limited to Europe. But if the idea is good, it can be recommended to other regions, and states may also adopt them as their choice of law rule. So, any question before we move from product liability? Hello? Hello?
Thank you, sir. Thank you, sir.
So you can see that most of the things you say, you are doing over syllabus. Even these your recommendations. They are largely over syllabus because you are not answering the questions we have asked you to answer. So see, each of you should see what you can do to understand the conventions scheme. The conventions combination and permutation is very important.
Yes, sir.
So let's move to the next, let's move to the contract people.
Yes, good evening, Prof. Good evening, class. My name is Ll.M.
3 members present now.
Yes, sir.
Okay.
So we have 5 chapters of our seminar paper. First one is introduction. Chapter 2 is determining the proper law.
Let me ask you a question.
Yes, sir.
Did we break contract into 2 or is it only 1?
We break it into 2 according to the course outline.
Okay, so there's going to be another paper on contract apart from yours.
Yes, sir. That's good. 3.
Okay, so you are discussing determining
the proper law.
of the proper law.
Yes, sir.
Okay. So the other people who are discussing what we call limitation of proper law. Okay. Function and limitation. Good.
Yes, sir.
So go ahead.
Thank you,
Sorry,
sir.
let me see whether I have your paper here. I think I've seen that paper this morning. Let me.
All right, sir.
Yes, group 2, determination of the proper law of contract. Okay?
Yes, sir. I'll be the one to present.
Seriki Mistura.
Yes, sir.
Adebayo David Adewumi. Odeyemi Mudashiru Olalekan.
Yes, sir.
Are we good to go?
Yes, sir.
Okay. Yes.
So Ll.M. will be the one to present parts 1 and 3. While Ll.M. will present 2, and David present the other part of the papers. So I'm starting with the introduction. We have 5 chapters. The first chapter is introduction. So what is meant by proper law of contract? Proper law of contract is choosing the appropriate law which will be applicable to a contract which is amenable to more than a law by the parties. The parties must have agreed the terms and conditions to govern the contract. That's the proper law. It is necessary to know the law that governs the contract agreement between parties, which involves international contracts, to be easier for determination when there is dispute. So if there are agreements regarding the terms and conditions, it will be easier for the court to determine and to enforce such a contract. But where the parties have no prior agreement on it, it will be a bit difficult to determine, to be determined by some objective tests by the court. So when parties agreed, or one party chooses to make an agreement regarding the contract, from initial stage, it
Well, I'm not hearing you again, oh. Sister Mistura, we are not hearing you again. What is happening? We are not hearing the
hello, sir.
presenter.
Can you hear me now? I think it's the network, sir.
Yes.
Yes, sir. I said if the party has agreed on terms or choice of law to govern the contract, it will be easier for the court to determine at the point of dispute regarding such contracts. Though if they are making the contract, the agreement, it might be fees or rigid that it is hard. But at the point of determination by the court, it will make it easier, flexible, and more reasonable for the determination of the contract. So we have three types of proper law of contract. We have express choice of law, we have implied, and we have imputed choice. Express choice of law is where the parties have agreed on terms and conditions on choice of law or the jurisdiction to govern such a contract. So the implied is where there is no express law, express agreement, I mean, regarding such, but the court will look at the circumstances surrounding the contract to infer the determination of the dispute in the transaction. While imputed choice is where there is neither express nor implied. So now I will leave chapter 2 to a colleague of mine to present, while I will later take part 3 of the paper, sir. But that's the introduction part, sir.
Good.
Yes, sir. And then we'll make part 2 of the paper. Or David. Hello? Hello?
Good evening, class. This is David. In the absence of my other colleague taking the chapter 2, I will be taking the chapter 2.
Chapter 2 is leave chapter 2 alone. Go to chapter 3.
All right.
Okay,
determining proper law of contract. That is the main issue.
Yes. So
okay.
I'll be the one to take that, sir. Ll.M will still take part 3, sir. So
Okay.
yes, part 3 deals with determining the proper law of contract. The law of contract, as Abelia said, that it's the general rule is that the parties may have intention of the agreement, the choice of law as to the contract, and the jurisdiction at times. It is governed by intention of the parties. So we have, in the case of Coastline Limited and Audis and Vendors, it was determined that the parties intended the contract to be governed, or where their intention is neither expressed nor to be inferred from the light is off. Okay, from the, I'm sorry, Prof, the NEPA interrupted the light here, I couldn't see what. So where the intention is neither expressed or be inferred from the circumstance system of the law, which transaction has its closeness and a real connection in the case of Mount Albert Borough Council and Australia, where it is decided that the law which the English court is applied in determining the obligation under the contract. English law in this matter has refused to treat as conclusive, rigid or arbitrary criteria, such as less lossy solutionists and less lossy contractors, has treated the matter as depending on the intention of the party to be ascertained in each case on the consideration of the terms of contract, the situation of the parties and the surrounding factors. It can be deduced from the above definition that what constitutes the proper law is not easy to determine because of its complexity, as it is entered into various kinds of contracts, such as sales of goods, hire purchase, contracts of employment, equipment leasing, consignment, and so on. Banks margin to up their minimum shares from 2 billion to 25 billion Nigeria cannot be easily determined. Or when it is determined, you can't compare with that of that shipment or consignment. Hello? Hello?
We're listening to you.
Okay, sir. There are various
But stop
kinds of
reading. Speak to
contracts.
the paper, please. We can read your paper later. Just speak to it.
Yes, sir.
Go to
Differences in proper law that
express
governs various
selection.
kinds of contracts. We have express selection of choice of law, sir.
Yes, go to express selection. What do we mean
Yes,
by
sir.
express selection?
Express selection is where the parties agreed on choice of law to determine the transaction, the contract. Parties have rights to choose a choice of law that will govern the
Tell us what
determination.
happened in Vital Food Product Limited
Yes,
and Unit
Vital
Shipping.
Products limits the position of detention of parties regarding the agreement, provided if the intention of the parties is bona fide, legal, and support the public policy, not that one person with the benefit on the detriment of the other party. So that is Vital Food case, the limitation in it. That is where the limitation to intention of parties.
Wait. Teach us now.
Yes,
Teach
sir.
us.
Yes, sir.
Express choice
Yes,
simply
sir.
means that the parties can fix the law of any particular country as the governing law.
Yes,
Is
sir.
there any limitation in their power to do so?
Yes, sir. That is in the case of Vital Foods case, where it is decided that though parties can have intention to choose choice of law to govern it, but provided if the intention, the agreement they have is legal, bona fide, and it doesn't against the public policy.
What did Agbede say about those conditionalities? If you read Agbede, what did he say about those conditionalities that the Privy Council appeared to have?
I didn't read Agbede.
What did he say? Agbede said that those conditionalities are meaningless. He said that they are meaningless, especially in the context of the issue of that case. Can you give us the fact of that case itself? Can you give us the fact of the case? Do you know the fact of the case? Hello?
Yes, sir.
It's there in your writing now. Read it. Read the fact of the case vis-a-vis the conditionalities for express choice.
I'm sorry, Prof. I've not found it, sir.
Okay, let me read it for you. After page 10, in page 11.
Okay,
The Nova Scotian Shipping Company, having agreed to carry goods from Newfoundland to New York, signed bills that omitted the express clause. The bills expressly provided that the contract should be governed by English law.
Yes.
Both the rules and the bills themselves exempted the company from liability for the negligence of the master. Newfoundland was admitted as the country with which the contract had the most substantial connection. There was no factual connection with England whatsoever. The cargo was damaged owing to the negligent navigation of the master, and the question was whether the company was liable. The court held that the company is not liable. The reason being that the Newfoundland Statute, by a provision that clearly affected the creation of the contract, compulsorily imposed the 8 rules upon the parties, and it was therefore by reason of these rules that the company justified their claim to exemption from liability. The Privy Council, however, held that it could be rested upon the rules as the selection of English law to govern contract was effective in spite of the fact that English law has no connection with the contract. And by English law, the rules applied to an outward shipment from England, not to a shipment from, the rules applied to an outward shipment to England, not to a shipment from any other country. So, Lord Wright, who delivered the lead judgment on behalf of the other 3 law lords, said, where there is an express statement by the parties of their intention to select the law of the contract, it is difficult to see, yes, those were the exact words of Lord Wright, it is difficult to see what qualifications are possible. The intention expressed is bona fide and legal, and provided there is no reason for avoiding the choice on the ground of public policy. Okay? So, the usual issue to be interrogated in this is, can the parties to an international contract choose as the governing law the law of a territory that has nothing to do with the contract?
No, sir.
Did you say
sir.
no?
Yes, sir.
In the light of the decision in Union Shipping Company itself, is the answer really no or yes? Let me give you a factual question.
Yes, sir.
Suppose a company based in Nigeria
Yes, sir.
has entered into a contract with a company based in Algeria.
Okay, sir.
Okay? And suppose the parties chose the law of Germany
Okay.
as the governing law.
Okay, sir.
So a dispute has now arisen
Okay, sir.
as regard whether there was a breach or not.
Okay, sir.
If you apply the law of Germany, there will be no breach.
Yes, sir.
But if you apply either the law of Algeria or the law of Nigeria,
Yes, sir.
there will be a breach.
Yes, sir.
How should the court decide the matter? Which should the court say is the law that will govern the transaction?
The court will look at if there's no express, the court will look.
I've told you that there is express now. They've
Yes,
chosen German
the
law.
court will look at the
Germany
facts.
has nothing to do with the contract.
Yes, sir. The court will look at the circumstantial facts surrounding the contract to determine which of the choice of law that will be applicable, because the Germany law might be favorable to either of the party in detriment of the other.
So the court would be bothered about the court will first think about the result before applying the law.
Yes, sir.
No, that is not right. That is not right. You told us now that the proper law of tort, the proper law of contract rather, intends to give effect to the party's intention.
Yes, sir.
And the parties have intended that German law should govern, and they have stated it expressly.
Yes, sir.
Rule number 1 says if there is an express choice, that choice governs.
Yes,
They've
sir.
chosen German law.
Okay, sir.
Okay?
Yes, sir.
Why should the court, at the point where the court's role is to activate the party's intention. Why should the court be bothered about who is affected positively or who is affected negatively by the choice that both parties
have agreed,
expressly made? Do you understand what I'm saying?
Yes, sir. Yes, sir. It is not the business of the court.
So the simple answer will be there is an express choice. The express choice governs. But you see, Law Wright created a problem because he talked too much. That statement he made, what's that statement again? He said, provided the choice is bona fide,
legal and not contrary to public policy.
not contrary to public policy.
Yes, sir.
Agbede said that qualification is meaningless. Why did he say it's meaningless? There is something that is called operative illegality in the law of contract. Okay?
Yes, sir. Illegality. All right, sir.
Operative illegality in the law of contract, because a contract involves, an international contract involves contact with several countries.
Yes, sir.
The country of entering into it may be different from the country of performing it.
Yes, sir.
It may be different from the country where the breach occurred.
Yes, sir.
It may be different from the country where action is instituted. So you have different contacts.
Yes, sir.
Okay?
Yes, sir.
When you are talking about public policy, the public policy you are talking about is the public policy of the forum. That is the court where the action is instituted. Okay? So,
yes,
public policy of the forum, if it is contrary to the law chosen by the parties, then the contract will be an illegal contract. If the public policy of the forum forbids that contract, notwithstanding that the proper law allows it, the public policy of the forum will be operative to deny the parties their wish.
Okay,
At least
sir.
not in that country. You can go and do whatever you want as well, but you cannot seek the assistance of our court to give effect to this type of contract. That's public policy.
Yes, sir.
Then, if you are complaining about formal validity, the parties would have had to comply with the lex loci contractus. If you want to make a contract in Nigeria, you have to look at what Nigerian law says regarding the form in which the contract will be made. There are some contracts that will not be valid unless they are sealed. There are others that the parties only need writing and signing. Okay? We have some contracts that written memorandum is required. So you can't be presenting a Nigeria-made contract for land and say there is no written evidence of it. So what are we saying? We are saying that formal validity will be governed by the lex loci contractus, the law of the place where the contract is made. So notwithstanding that the proper law of the contract might have allowed it in an oral form, if the contract was made in countrywide, whose law required that it must be in a written form, the lack of compliance with that requirement of the locus contractus would also invalidate the contract. So that illegality will be operative. Then, if the parties knowingly chose the law of a particular country as the governing law of their contract, And it turned out that something that they have provided for as a term in that contract is illegal under that proper law, under that choosing law. The cases say that that illegality will operate because they of their own said this contract is going to be governed by the law of this state. Okay? And the state whose law they have chosen forbids some terms of the contract. So that those terms will become illegal and unenforceable on that basis. So that is the topic of operative illegality. And Agbede was trying to explain that there's a difference between the question of parties' choice of a proper law and the type of illegality that could affect their choice. And so his lordship ought not to have even dabbled into what he dabbled into. Meaning that in reality, there is no conditionality that will prevent the party's separate choice to apply. Okay? But did you discuss a Nigerian case on the matter? There's a Nigerian case on the matter. Did you discuss it?
Yes, sir. At the last part of the...
What is the case?
RTC versus FOB Investment Property Limited.
I don't even know that one. There is a very popular case, a 1987 case. There's a 1987 case that threw up issue of exclusive foreign jurisdiction, issue of proper law of contracts, where the parties especially chose German law, I think. And the Nigerian court condemned the parties for choosing a law that has nothing to do with the contract. Is there anybody who know that case? I don't know what I have done with the case. It has skipped my brain. Is there anybody who knows that case? At any rate, the Supreme Court in that case seemed to have confined the party's right to choose a governing law to choosing between the law of the different countries that have contact with the contracts. So in other words, they ignore the actual decision in this case we are analyzing. Because what happened in that case was that the choice of English law by the parties, but for their choice, there is no way English law would have applied. The contract had nothing to do with English law, but the parties chose English law. And the court nevertheless applied their choice. Okay? But the Nigerian court in that particular case held that the choice of German law was extraneous because Germany was not one of the contacts. It was neither the local contractors nor the local solutionists, etc., etc. So for that reason, they pronounce against the application of German law. Okay? Clearly, the decision is contrary to the ratio of this case, but they may have wrongly highlighted the unnecessary conditionalities which the the court in Vital Food Products Incorporation and Unit Shipping had mistakenly imposed. Okay?
Yes, sir.
So the controversy in this area is there any limitation in the party's choice? Are the parties limited to picking between states that have connection with the contract, or can they just choose any law? So, and as I've explained, if the parties to the contract are based in Nigeria and Algeria, why should German law be the governing law? Nigerian courts, in that particular case, I will remember the case, seem to have suggested that there is a limitation. But the correct English position is that there is no limitation.
Is it Sona Nigeria Limited?
Yes,
Versus?
and not wind. That's the case.
Yes, sir.
That's the case. That's the case. Our courts seem to have decided to the contrary in those cases. And many of our court decisions in this subject area, I don't know. I've looked at their decision in the area of proper law, in the area of jurisdictional immunity, and what have you. And yes, that is the case. Somebody, Mr. David Ogwedi, has given us the case, Sona and Sona something Patenderi and Nordwin. A name that sounded India. Okay? So that is the controversy in that area. And we are waiting for an opportunity to correct the wrong impression that the Supreme Court had in that case. So go to, okay, you have discussed it now, limitation to the selection of the proper law.
Yes, sir.
Okay. But you didn't discuss Sona and Nordwind there now. Where did you discuss Sona and Nordwind? Okay, what happened in the cases you discussed?
I discussed Golden Acres Limited versus Queensland Estate Property Limited.
So what happened there?
So this is where the court refused to apply the law of Hong Kong to the contract of parties. That is the contract between the claimant Freehold Land Investment Limited and the defendant, Queensland Estates Property Limited. The principle laid down in Vital Foods case, which limits the intention of the party, is very much in operation.
But you see what you are saying? Yes, that was a case of operative illegality. That's what Agbede is explaining. Okay. That you don't mix issues up. It's not because the court is not willing, to apply the express choice. It's because there's an operative illegality. Okay?
Yes, sir.
The judge was satisfied, however, that the selection of a law other than that of Queensland was made for the specific purpose of avoiding the consequences of the illegality which you follow if Queensland law applied. The judge concluded that the choice of Hong Kong law was not bona fide and proceeded to determine the case on the basis that the law of Queensland was applicable to the claim. Okay? Yes, the deed was executed in Queensland. Let's see. Okay, there is a clause. They inserted a clause. For all purposes arising under this agreement, the same shall be deemed to be entered into in the colony of Hong Kong. Okay, but the deed was executed in Queensland. So the lex loci contractus was supposed to govern a particular matter. Okay, the choice of Hong Kong law is not the problem, but there is an issue of operative illegality in the sense that the contract was illegal according to the lex loci contractus. Okay, maybe it didn't meet a particular formality and whatever. That's what it's a very technical point, but you do not just exclude the party's choice simply because the local contractors or local solutionists provide otherwise. Okay?
Yes, sir.
At any rate, you have seen what Nigerian court had done, Nigerian court's own view on the matter, which is really, really contrary to the English court's view. Okay? Some of these cases are very old. There are cases decided at the time when the court have not decided on the proper law as a test. So you must understand their limitation. Now, what happened in Compare Damanti Maritime Essay, read Tunisiani? What happened there? Hello? What happened in read Tunisiani? You cited read Tunisiani.
Yes, sir.
Yes.
It's breaking, sir.
What happened in read Tunisiani? Read Tunisiani. Compagnie
Because the
d'Armament
party
Maritime.
choose jurisdiction but fail to choose the law to be applied, the choice of jurisdiction can also be governed by the contract. Where they choose the jurisdiction and they fail to apply, to choose the applicable law.
Read Tunisiani is usually used to explain implied choice.
Okay,
Do you
sir?
understand?
Yes, sir.
Most conflict of law textbook will use read Tunisiani to explain implied choice. Because
Yes, sir.
what happened in that case was that there was no express choice according to the court, because the express choice according to the court was meaningless. That is, this contract shall be governed by the laws of the flag of the vessel carrying the goods. The court said, but the court said that that clause is a meaningless choice of law clause. But there was another clause that said all the disputes are to be settled in London. And so the English court was willing to hold that it will be implied that the agreed place of arbitration is also the applicable law. So we use read Tunisiani to explain implied choice. And one of the examples we will usually give is that if your international contract has a choice of jurisdiction clause, but not a choice of law clause, or its choice of law clause is meaningless, as the court had said in read Tunisiani, then it will be implied that you also intended the law of the place of arbitration to apply. So read Tunisiani is not an example of conditionalities or limitation to choice of law. Okay? So go to implied selection of the proper law. Hello? Hello? What is happening now? I'm not hearing you again, no.
Hello, sir.
We are Mr. Adewumi.
Uh,
Go to implied selection of proper law. What did you say there? Give us
my
one or two
selection.
sentences. Yes?
That's the part for my colleague to present, but in the absence of our presentation, I'm sorry, please hold on. I'm in transit, so it's difficult for me to check the states. Okay. Well, can you please stop that? Okay. Implied selection of the proper law, as put in chapter 3.3. She talked about the case of Jacobs, Marcos, and Credit's Lioness, where the plaintiffs were Espato Merchant and the defendants were a banking company, respectively, both carrying on business in London. And by a contract made in London, the defendants agreed to sell the plaintiffs 20,000 tons of Algerian Espato. By the terms of the contract, the Espato was to be shipped from a French company at an Algerian port over a period of 12 months in equal proportions per month as far as possible. The provision was made that by the contract for the determination of the quantity for each month, plaintiffs were under obligation to provide ships or steamers to take delivery at a certain specified daily tonnage. The Espato was to be paid for by the plaintiff in cash in London on or before arrival of the ships at ports of destination, less interest at 5% of the unexpired portion of the 3 months. From date of bill of lading for the full amount of the invoice based on shipping, defendants were made one monthly delivery. The defendants made one monthly delivery in accordance with the contract, but failed thereafter, either wholly or in part, to give notice of subsequent monthly deliveries or to make delivery of the quantities specified. An action being taken for damages for breach of the contract. The defendant rejected time of the contract insurrection in Algeria. This caused their non-performance of the contract. The plaintiffs claimed it governed by English law, said the defendant's claim. The crucial focus of this case was that
Anyway, time is fast spent. Let me help you. Time is fast spent. I've looked at the cases you people discussed under implied.
Into the four corners of the.
Hello, Mr. David. I've looked at the cases you people discussed under implied choice. Okay? The ones that clearly relate to implied choice are I think Tosis and Monarch. Sources and monarch
Okay.
was the case where the court implied the choice of, in the case of Sources and monarch, a contract made and to be performed in Sweden for the sale of a ship by Swedish sellers to Greek buyers had no connection whatsoever with English law, but it provided that arbitration would be in London. The Court of Appeal held that English law was the proper law of the contract. Salman L.J. said the arbitration clauses raises an irresistible inference which overrides all other factors. So when we are talking about implied choice, we are saying that the parties have not made an express choice.
Yes.
We are not saying that somebody will contradict their express choice by using his own common sense. We are saying that they have not made an express choice. Okay? But reading through the terms of the contract, you can imply one from there. So, Sources and monarch and writ tunisienne are two cases that demonstrate how implied choice inference is done. In writ tunisienne, the court knocked out the party's express choice, saying it was meaningless. But the court applied the party's choice of a place of arbitration and said that since the parties are agreed on a place to litigate, it will be presumed that the parties also intended that the law of that place should be the governing law. So you look at Sources and monarch, you look at writ tunisienne, both of them explain implied choice. So implied choice will just mean looking at some of the settled terms of the contract and implying from those terms that this is the law that the parties intended. Okay? That's the meaning of the Tunisian. You also cited the Tunisian, although you did not highlight it. Those are the cases that explain implied choice. And I'm surprised that it is under that one that you are discussing Sona and Nordwind. Sona and Nordwind is an authority for limiting the parties' rights to choose the law of a country that has nothing to do with the contract. And it doesn't follow the ratio of English decision on the matter, unless our court were actually deliberately intending to depart from the clear position of English conflict of laws. Their decision would appear to be erroneous, but we'll wait for opportunity for them to review whatever they did. So let's move to the third option. What is the third resort? When you cannot, where there is no express choice, and you cannot imply one from the terms of the contract, what is the next thing you do?
Okay.
Yes.
The third one is the closest and the most real connection.
Yes.
When the intention of the parties with to a contract with regard to the law governing it is not expressed and cannot be inferred from the circumstances, the contract is governed by the system of law with which the transaction has its closest and most real connection. This was highlighted in the case of Mount Albert Borough Council and Australasian Life Insurance Society Limited. In this case, the appellants, a New Zealand Borough Council and a local body within the New Zealand Local Bodies Loans Act, borrowed money for public works from the respondents, a company incorporated in Victoria, Australia, and carrying on business in Australia and New Zealand. As security for the loan, the appellants issued a New Zealand debentures totaling £130,000 sterling repayable in Melbourne, Victoria, and bearing interest payable in Melbourne half yearly. The debentures were issued and local bodies loan acts of the New Zealand, and the loan interest were secured on a special rate. The respondents claimed certain interest in due on the principal amount. The appellants, however, paid £3,250 pounds sterling, alleging that as the interest was payable at Melbourne, the payment was governed by the Financial Emergency Acts of Victoria, which provided for a reduction in the rates of interest on mortgages and other securities. In interpreting this, Lord Wright said, the parties may not have thought of the matter at all. Then the court has to impute an intention or to determine for the parties what is the proper law, which as just as unreasonable persons, they ought to or would have intended if they had thought about the question when they made the contract. This subjective test, which imposes the proper law on the test, where they could not provide the law expressly or where the law cannot be implied or inferred and cannot be ascertained from the surrounding circumstances embedded in the terms and conditions as well as the nature of the contract. This principle, therefore, is to look at what constitutes the proper law from the outside and what can be regarded as third parties. That is where reasonable men in the standing of the parties would regard as a proper law of the contract. After examining the surrounding circumstances of the case as reasonable businessmen who are in the same footing and standing as the contracting parties would have examined same. We went further by saying in the case of United Railways of Havana and regular warehouses, where Lord Dana held that the test is simply with what country has the transaction the closest and most real connection. The criteria formulated here is to assist the court in determining the proper law through the test of the reasonable man.
Sorry, go to your Nigerian case of RTC and FOB Investment and Property Limited.
Okay, in RTC versus FOB Investment and Property Limited, the Court of Appeals sitting in Lagos, Nigeria, applied the objective test in resolving a preliminary question before the court, which was, which country, as between Nigeria and United States of America, had jurisdiction in a breach of contract case? In this case, the second respondent was the director.
It's a jurisdiction issue. We are talking of law. I analyzed that case in my book. In my book on jurisdiction, it's not relevant. It's a the issue here is a jurisdiction issue. You are in a conflict of law class. When we are talking about choice of law, don't bring a decision on jurisdiction. It's not relevant.
Okay, sir. Noted, sir.
So it's not relevant. I have seen that it's not relevant.
Okay,
so,
sir.
In summary, when there is no express or implied choice, what would the court do?
When there's implied choice, the court would...
when there is no express or implied choice, what would the court do?
When there's no express or implied choice, the court would look at the test of a reasonable man, apply the test of a reasonable man to see what country has the closest and most real connection to the subject matter.
How does the court determine the country that has the most significant and real connection? How do they determine it?
The court would look at where the contract originated from, the parties, where they stay, or where the contract is expected to be performed. The one that has the most substantial connection is where the court would most likely adopt as having the governing laws in respect of that dispute.
The court will look at the contact which different legal districts have with the contracts.
Yes.
Okay. And they will apply what is called the center of gravity test.
Yes.
Okay? The center of gravity test. That is in which of the different legal districts would both parties have to do more things than the others?
Yes.
So when they arrive at that, they will then say that is the country whose law the parties will be deemed to have intended. I'm a textbook person. Some of these difficult things, they are better explained in a textbook. So I am armed with my Morris. There's a particular case that I use to illustrate that point. That I normally use to illustrate that point from Morris' Conflict of Laws book. I'm coming.
Hello.
I'm coming.
Okay, sir.
There are some topics that we cannot rush. They are the foundation of what we are doing. So no matter how much we are in a hurry, we shouldn't rush contracts. Yes, this is it. The Azuzione, did you discuss the Azuzione? Hello?
Hello, sir. I didn't hear that, sir.
There's a case called the Azuzione, Assunzione, Azuzione.
Okay.
Go and read it in page 336 of Morris' book.
Okay.
Okay? The facts. The contract was one for the carriage of wheat from Dunkirk to Venice on board an Italian ship. The charterers were an organization of French grain merchants. The wheat was shipped under an exchange agreement between the French and Italian governments. But the Italian ship owners did not know this. The contract was negotiated by correspondence between brokers in France and brokers in Italy. It was formally concluded in Paris in the English language and in an English standard form. Freight and demurrage were payable in Italian currency in Italy. Okay? So you will see that you cannot easily imply a choice in this because the contracts appear balanced. Okay? The contracts appear balanced. There were things to be done in Italy and things to be done in France. And so, unlike Lee Tunisene, it was not easy to imply, or something like Monarch, it was not easy to imply a choice of law from one particular clause. So, how did the court arrive at Italian law as the governing law? The court said that Italy was the place where both parties had contractual obligations to perform. Okay? Since both parties have obligation to perform in Italy, Italy will be the governing law as the center of gravity. So what we normally teach in this area is that if you do not want the courts to impose on you a choice that you do not desire, it is better for you to express a choice. If you do not express a choice, you might find yourself in the Azuzione position, where by the time you go to court to enforce the contract on the assumption that the law of state will govern, the court will rationalize everything and say, well, it is the law of state B that has the closest and most real connection. Okay? Is it clear?
Yes, sir.
So, what did you answer? What other questions did you answer? You look at merit and the merits of proper law. I don't think I'm interested in all of that.
Okay. In our chapter 4, sir, we talked about the essential elements of contracts and proper law.
Essential element of proper law, and you are that one is for the next paper. Is for the
Sir.
paper we will discuss limitation.
Noted,
What
sir.
we are simply saying under that one is that you can only be talking about proper law if the parties agreed there was a contract. And so when one of them wants to enforce the terms of the contract, and you have to determine under what law we do it, you can then say under the law chosen by the parties, in the absence of an express choice, under the law implied by the parties, and in the absence of express or implied choice, under the law with the most significant and real connection with the contract. So what we are saying here is that there are some elements that must be met before there is a contract. What is the law that will govern any dispute relating to those elements? For example, if one of the parties is saying, there wasn't even a contract, he made an offer, I didn't accept. How do you then go to an express choice to determine that issue? It doesn't make sense. The express choice can only be relevant if a contract was concluded and the parties are added them that there was a contract. But this one is saying there was no contract. Okay? So this your topic is supposed to be merged with the second paper on contract. But there are other issues under your topic that you didn't discuss, which all of you will go and look at in a relevant article or textbook. The first issue there is we are saying that the parties have a right to choose. What do they have a right to choose? Is it a territorial law or a rule of law? Your paper has not answered that question, and your paper should answer it. Okay? What is the difference between a territorial law or a rule of law? What is the difference between the two? The parties can choose Gambian law, for example, to govern their contracts. But they can also choose the Hague rules on carriage of goods by sea. Now, Hague rule on carriage of goods by sea may be part of Gambian law. By choosing Gambian law, they may have made the Hague rule on carriage of goods by sea applicable. So Hague rule is a rule of law, but it will be applied as a territorial law of Gambia because Gambia is a member of that treaty and has domesticated the treaty or by its own system, the treaty automatically applies. Now, suppose a contract is made between two persons belonging to two different countries, and neither of their two countries is a member to the Convention on Carriage of Goods by Sea. Yet, the contract presented that it is the Hague rules of carriage of goods by sea that will govern. When that happens, the parties have chosen a rule of law, not a territorial law. Okay? So, is it possible? Is it possible? Are the parties allowed to choose a non-territorial law, a law that is not the law of any state, but is nevertheless a rule of law? Like the rules made pursuant to a treaty, e.g., the rules on carriage of goods by sea under a convention, or the rules on carriage of goods by air under a convention. That's what we are saying. Did you research into that?
No, sir, we
Hello?
didn't.
You
We did not,
didn't.
sir.
No, sir.
You didn't.
Yes, sir.
Okay. Well, the position of English law used to be that the parties are free to choose non-territorial rules of law as the governing law of their contracts. They are free to choose non-territorial rules of law as the governing law of their contracts. But England membership of European Union has meant that that will no longer be the case, because the relevant article of the European Convention limits parties' choice to the law of a state. The law of a state. So at common law, it was quite possible to agree on a rule of law which is not the law of a particular state. And so you can argue that the Nigerian position would remain the common law position, so that the party's choice will not be limited to a territorial law. They can agree on a system or rule of law that is not the law of any particular country. But the English jurisdiction has lost that latitude because European rules forbid the choice of any law other than a state law. Is it clear?
Yes, sir.
So it doesn't have to be a territorial law. Okay? The other issue is the difference between the choice of a state law and the adoption of a state law by reference. What is the difference between a clause that says the contract is going to be governed by Ghanaian law and a contract that says the law that will govern this contract is XYZ statute of Ghana? XYZ of statute of Ghana that entered into force on so date of so. What's the difference between the two? A contract, an international contract, chose as its governing law the law of Ghana. If the law in Ghana is XYZ statute, that law will apply. Now, but if, as at the time of filing action to enforce the contract, XYZ has changed to ABC in Ghana, which law will the court apply? Can somebody answer that question? I give you two scenarios. A and B resident or carry on business in Ghana and Nigeria respectively, provide in their contract that the governing law of the contract will be Ghanaian law. That's scenario one. Scenario two, A and B provide in their contract that the governing law of this contract will be XYZ statute of Ghana that entered into force on so date of so month of so year. What is the difference between the two? Especially if the Ghanaian authority had gone ahead to amend the XYZ statute as at the date of the action. Yes? Can somebody answer that? Can somebody differentiate between the two?
So in the first instance where it's put on the contract that the laws of Ghana would apply blanketly like that, which is not restrictive to one particular law per se. So if there's a change in the normal applicable law into another law, then that would still be deemed fit to be applied in that scenario. But in a case where it was expressly put that this is the particular law they want to be referred to when it comes to this resolution, and that law has been amended or changed abruptly or whichever way, then that law would not apply in this case into the amended or the repealed one. In that case, the court would imply, looking at the center of gravity test, now utilizing that now to see that outside of the expressly mentioned law that is no longer in existence right now, what other factor, what other connection does the contract have to what other country or jurisdiction has the closest link to the scenario, the circumstance in this instance, and then that law of that jurisdiction will be applicable.
I know where you are going, but you are wrong. You are wrong. It's a time factor issue. I taught you time factor in the first semester. It's a time factor issue. Okay?
Okay, yes.
If the parties chose Ghanaian law to govern their contracts, the fact that the Ghanaian law at the time of their contract is XYZ statute does not mean that the new ABC statute, which is also a Ghanaian statute, will not apply. So time will not be a factor. But if the parties incorporated Ghanaian XYZ statute, which entered into force on so date, as the governing law of their contract, okay? What it simply means is that nothing that happened in Ghana would affect their choice. So even if tomorrow Ghana repeals XYZ statute, it's none of their business. XYZ statute will still apply to be the governing law of their contract. Is it clear?
Yes, sir.
Yes, sir, it is.
So in the later case, time will be a factor. What the parties have simply done is to use a formula to incorporate XYZ statute into their contract. Since the rule will permit them to agree on any term. XYZ statute has been incorporated at the time of their contract. And so it has nothing to do with the Ghanaian legislative authority. And so if Ghana amends that statute, Ghana has done so for Ghana's purpose. For the purpose of their contract, they stick to XYZ statute. Is it clear?
Yes, sir.
Okay.
Yes, sir, it's clear. So I have a question.
Yes.
What would be the scenario if application of that repealed law is contrary to, giving effect to that law is contrary to public policy in Ghana as it stands? The law is outdated and has been.
If the action is going on in Ghana, public policy is a forum conditionality for applicability of governing law. Do you understand? Suppose
Yes,
the case is going on in England or in Nigeria, it will not matter that Ghanaian public policy forbids the application of XYZ statute. Do you understand?
Yes, sir.
But if the action is going on in Ghana, you don't need anybody to tell you that that statute, the XYZ statute, might be contrary to public policy of Ghana. And the Ghanaian court might not be willing to give effect to it. Okay?
Yes, sir.
So any other question?
No other questions, sir.
If there is no other question, do you want us to go to the second contract paper? I want to go and say my prayers. I want to go and say my prayers. Maybe we will find a way of covering uncovered ground in one Saturday. But we are really behind schedule. We are really behind schedule. So I think on that note, unless you want me to go and say my prayers and return, say by, if I come by 7:30, I will also leave by 8. Let's just be going on. Let's be going on. What?
Prof, I think your prayer is important.
Yes.
Maybe we'll continue in the next class, sir. My suggestion, sir.
Okay. So we see. I'm asking this question because I know we are behind schedule. We have missed a number of lectures. Some due to my fault, some due to nobody's fault. Do you understand?
Yes, sir.
Last week, I think, was it last week we were not able to do lecture?
Yes,
we did a lecture in the
last week.
And we didn't finish until around 4, when we had planned to finish by 2, and I was so weak and tired. Anyway, we'll make it up. We'll find a way of making up. So the next week we will take the remaining contract issue. That one will not take our time. Then we take it together with either trust or corporation. Let the presenters of the 3 remaining law topics, let them all be ready. Who knows? We might just be able to take the 3 topics on that day. Yes.
Sir. May I humbly ask if there could be a guideline for those that are also yet to present, so we don't waste time? Maybe there is a particular
you know
subject
what my
you want them.
problem is?
No, sir.
You know what my problem is?
No, sir.
What I keep seeing is that if you look at the papers thoroughly, you will see that everything you want to be said has been said, but because people do not know the confine of what we want them to say, they sometimes talk too much. And people do not really grasp what they are saying, so they can't speak to the paper. That is the reason why presentation takes an awfully longer time than is expected. But I think the way to go about it is the way I've gone about it today.
Yes,
Have the paper to be presented, go through them shortly before the presentation so that I can guide the presenter. This is what you want to hear. This is what you have not said, and all of that. I think that's the way we did it today, isn't it?
Yes, sir.
We
Yes,
have
sir.
Yes, sir.
allowed
That's
this
where we did it.
contract
Yes,
people
yes, sir.
to read all the things they have written. Maybe we will still be listening to them. Okay? So if we
Yes,
go
sir.
through their paper and see what is relevant, at the end of the day, what is it that they didn't discuss? The whole class will know that this paper, they didn't touch this issue, and you go and read it. Is
Thank you, sir.
that all right?
Yes,
sir.
sir. Thank you, sir.
We are grateful,
Okay.
sir.
We are grateful,
So,
sir.
yeah,
Thank you, sir.
you're welcome.
Thank you, sir. Good night,
Thank you,
sir.
sir.
Yeah,
We believe you are stronger now, sir. We thank God, sir.
yeah, we thank God Almighty.
Thank you, sir.
Yes,
Yeah,
sir.
okay.
Bye-bye,
Okay,
sir.
sir. Bye.
Thank you, sir.
Welcome.